Now, I'd like us to start this way. Let's go to the Ghana Bar Association's annual conference at the Kwame Nkrumah University of Science and Technology. Let's listen to Otumfuo Osei II, the king of the Ashanti Kingdom, on the judiciary.
Here we are today, struck down by the tsunami of scandal that threatens to wash away the integrity of the entire judicial arm of government. I speak with the pain of a nation betrayed and the anguish of a people ravaged, whose faith in their nation's most cherished institutions now lie in a crushed earth. The ultimate goodness of our countrymen, faith in our capacity to rise from the ashes of despair. For a start, the world can be assured that the commitment of the nation to democracy is irreversible. That the commitment, however, will be hollow without a robust, credible judicial arm. So there's no way that this nation is going to allow the judiciary, the judicial arm of government, or any of its institutions to wither away. Whatever it takes, however long it takes, all of us, chiefs and people, young and old, will rally together to salvage the integrity of the judiciary.
Osei II. Let's hear President John Agyekum Kufuor at the same occasion speaking about this scandal.
In times past, they were not even expected to socialize and mingle too easily within the community. The disgrace befalling our nation, our bench and our profession through the exposure should give all of us very rude shock and awakening. The solution should not lie in any superficial, piecemeal and orphan treatment, even as we contemplate arresting and eradicating the cancerous tumor. The entire nation should cast the net wider to the other organs of state, the executive, legislature, and indeed the entire public sector. The search should aim at thorough purging of the public sector of the society. If we are to be candid to ourselves, we should all admit that the canker has eaten deep and wide into the social fabric of our society and at all levels of society. Removing the scab on a sore should be the first step for treating this corruption. Our institutions for checking corruption do not seem to be working, and it has had to take the spearhead by a single individual to unearth corruption.
And that was former President Agyekum Kufuor speaking on the judicial corruption scandal that hits this country. Otumfuo refers to it as a tsunami, so to speak. There are others who have referred to it in similar fashion. Let's listen to the Chief Justice, Justice Georgina Theodora Wood.
The various alleged acts of gross misconduct, we will ensure that the rule of law, with all the constitutional guarantees and safeguards afforded to all persons accused of stated misconduct, are fully respected. We cannot do otherwise. We are a justice institution birthed in the principles of fair trial and the natural justice. Corruption, particularly judicial corruption, erodes public confidence, and from a development perspective, negatively impacts economic growth. How I pray that we will have a clear understanding of the full effects of a corrupt system the bar will join us and lead to manage this canker within the establishment. This is what makes events of the last 2 weeks particularly disturbing.
Chief Justice, Her Ladyship Theodora Georgina Wood. We'll listen now to the Deputy Attorney General, Dominic Ayine, Dr. Dominic Ayine. When we are done, we'll also hear briefly from the President of the Bar Association, outgoing President of the Bar Association, Nene Amegache. Later, I'll bring you some other footage by the Chief Justice and also by Dr. Kweku Ansah-Asare and some other claims that he's making and some other different way of diagnosing the particular situation that we are going to look at right away. So let's hear Dr. Dominic Ayine, Deputy Attorney General and Minister for Justice, and then after that we hear Nene Amegache briefly, very briefly, who is the outgoing President of the Ghana Bar Association.
The General Legal Council will continue to apply the rules fully against defaulting members with a view to weeding completely the bad nuts. I will therefore advise members to constantly check themselves and ensure that they are operating within the strict confines of the professional code of ethics.
And that was the President of the Ghana Bar Association, outgoing President of the Ghana Bar Association. Well, he, new President was elected just 2 days ago, so it's becoming a little difficult to say he is outgoing. The new President, sure, would have taken over by now. Now, let's listen to the Deputy Attorney General and Minister for Justice, Dr. Dominic Ayine. He also spoke at the opening ceremony of the annual conference of the Ghana Bar Association. Okay, I understand that I have a little problem with that particular sound. I'll bring it to you very soon because he's got some very important things to say about the judiciary and concerns, that observations that he's made, that they don't seem to now be giving judgments that are sound enough and that are laced with sufficient law, but appear to be judgments that are either compromised or just that you have judges who have become lazy, and those are his words, lazy. Well, we'll get that and get you to share in that sentiment as well. My guest starts. You are like to say, first of all, wish a recovery to supposed to be on this show. She really wanted to do the show. We can always do an, so I'm just wishing you the very best, that you recover quickly. May the healing power of Christ abound to you. And Justice Stephen Alan Brobe was supposed to be here in the studio. He will join us on the phone for good reason. He's unable to be here in the studio. He will join us on the phone to deal with a very critical matter briefly. He is a retired justice of the Supreme Court of Ghana. He is a teacher of lawyers, a teacher of judges, and has had to play some very pivotal role in automating the court system in Ghana. I also want to say I'm extremely grateful to the hard-working, outgoing GBA President, Nene Amegache, and the most dependable Secretary, Justin Amenuvo. Thank you for all the help you gave me in trying to get all of these very important guests together. Thank you very much. Now let's hear Dominic Ayine.
It is not sufficient to know the law of the realm. A person appointed to administer the law must also commit to observing the law. Observing the law well is what I mean by judicial integrity. A judge who means to observe the law well will appreciate an excellent brief written and filed by counsel and will not look the other way and give a ruling unsupported by sound legal reasoning. Unfortunately, at the risk of generalizing too much, it appears to me that with the exception of the Supreme Court, to some extent, legal arguments no longer count. So, well, yes, it's as good as mine. It's either that the judges are lazy or they are corrupted by influences other than the law. Your leadership, the Chief Justice, in order to restore judicial integrity where it is lacking, in this simplistic or rudimentary form, I have a proposition, and it is this. I propose that you make it compulsory that every morning, before your judges and court staff begin to work, they recite Article 40 of Magna Carta, which reads as follows. And Article 40, I saw that was, yes. To no one will we sell, to no one will we refuse or delay right or justice. If they recite this every morning, they'll remind themselves of the corrupting influence of. If any judge, registrar, court clerk, or bailiff does not agree to abide by this principle, then they should either resign or apply the proper rules of auction so that the market will determine the most efficient price payable. The rule of law and access to justice cannot flourish in our society if those who man our judicial system lack moral and ethical integrity. As Chaucer put it in his famous Canterbury Tales, if gold rusts, what shall iron do? The rule of law in the hands of a perverse judiciary is a very dangerous weapon. And again, I quote from Tamanaha in his book on the rule of law, history, politics, and theory, published in 2004. And he says, I quote, like the knife, which is neither good nor bad in itself, but can be used to kill a man or to slice vegetables, law is a function of the use of dispute. Rule of law, the service of an legal regime, would be immoral. My proposition is made in and should never be the integrity of our judiciary. And I bet there are men integrity on the bench. Emphasize that men and women of integrity on the bench.
You're welcome back, and that is the Deputy Attorney General, Minister of Justice, Dr. Dominic Ayine, speaking at the Bar Association's annual conference at the opening at the Kwame Nkrumah University of Science and Technology in Kumasi. My guests are seated. Abdul Malik Kubako. He is Editor-in-Chief of the New Crusading Guide newspaper. Ace Anan Ankoma is a private legal practitioner. He's with OG. Occupy Ghana. Also in the studio is Joyce Bawa Mokhtar. She is a Deputy Transport Minister. She's also a lawyer. And Egbert Fable Jr. is a private legal practitioner and managing editor of the Ghanaian Observer newspaper. As I announced earlier, on the phone we'll be speaking to Justice Stephen Alan Brobe, a retired justice of the Supreme Court of Ghana. Ladies and gentlemen, I am very excited to have you in the studio. Good morning.
Good morning. Good morning.
Great to have you. Now, I start with ACE, the Bar Association's conference. The theme had nothing to do with all that we heard. What happened?
Well, I think there's a classic case of being overtaken by events. And well, we're talking about words like panacea, etc., etc. So it kind of dovetailed into each other. There was no way that the bar could pretend, after it has set its theme, that what had happened was irrelevant. So actually the theme and many things at the conference got overtaken by the reality on the ground. All the speakers at the opening ceremony addressed this issue, and so it was only fair, it was only right that it becomes center, a key point. In the formal discussions, in the informal discussions, that was what everybody was talking about.
Very interesting. Of course, it could not have been avoided, as Isan Kuma just says. And Egbert, you saw that obviously was a situation, nothing could have been done about it.
Oh, but of course, I mean, it is really realistic and pragmatic that, you know, whatever had been planned against the backdrop of what we are being confronted with presently should have a certain synthesis. Otherwise, they will say that we're playing ostrich.
Kuku, I'm very sure that you tuned in and you were listening and watching to see what was happening at the conference.
I would disappoint you because I was distracted by some urgent family business.
Okay.
You know, so I was unable to follow it when it was live. But post the event, few tidbits here and there, I was able to follow, track. But really not when it was a live proceeding.
And what did you make of the statements that were made by the various speakers, the Asante-Hene, Otumfuo Osei II, President Kufuor, the Bar President himself, the Chief Justice, and Dr.
I think they were all spot on. They captured the mood of the times, the spirit of the occasion. They had to look at those issues and highlight it. And the kind of authority they brought to bear, you know, on that issue for me was remarkable. And it set the tone that, look here, this serious business, let's not toy around with it, let's focus and deal with it properly.
Right. Yeah. Like Egbert, I'm not sure I saw you at the conference, but you monitored, right?
Well, certainly I did. In fact, I was at the conference.
Oh, you did?
First day.
Okay.
I actually saw you, but I tell people all the time, I'm probably one of the few government appointees that most people somehow are unable to recognize all the time. But yes, actually there, I followed things carefully. And indeed, I think I would agree with the other speakers that in the event actually portend the speeches that we all sat and to. Apparently, it was actually almost, there were two schools. There were those who actually thought that for the first time, maybe it would probably have been appropriate, even under the circumstances, for us not to attend the conference at all. But then, of course, a lot of preparations had gone into it, and I believe that there was also a need for us to reflect. I think it called for deeper reflection, a deeper illumination on the events of our times that actually had unfolded prior to the conference. I also think that it also gave a platform to other members, senior members of the bar, to actually comment on issues that actually preceded.
Reassuring for you?
Well, I don't think we can all find any sort of reassurance really in speeches, because I think that these are things that we've been actually talking about for quite some time. What I think really is that people expect to see some sort of change, some modicum of remorse that things should be done differently going forward. I think the speeches just actually captured the mood of the conference on that particular day. And I do hope that as we go along, that the speeches will come to have even more of a reflection, a meaning for us all by whatever actions are taken going forward.
But if you look at the theme, it may appear also that the speeches were not a departure from the theme. The theme was rule of law, access to justice and sustainable development, the panacea to political and economic progress of a nation. Well, if the judges will not deliver judgments that are quote-unquote sacrosanct, then you can't talk about rule of law and access to justice.
Well, you can look at it from that perspective, but now if you find yourself also in the shoes of the judges who have been caught in this vortex, it is also proper to say that the theme, the bit about rule of law, should be allowed to prevail, because if there's rule of law, even though there is a tape and all those things, they are supposed to go through due process.
Right.
So the issue now is to show or not to show, you know, as Anas himself has put forth in a certain skit. So yes, the theme very relevant, even using as a dashboard to guide us to a resolution of the current, you know, sort of conundrum that we find ourselves in.
Kuku, how does it come to you that as we speak, There are writs, suits, left, right, center, writs and suits that are being filed almost every day against this expose.
Well, I believe in the rule of law. I'm a Democrat, so I wouldn't say this exercise or those rates are of nuisance value. I wouldn't say that. They are welcome. Okay? Let them go through the processes. It will be difficult to suggest that why are you doing this? Why? I feel uncomfortable with some of those initiatives. And look, I'm restraining myself. Because you see,
you're
sometimes...
restraining yourself from repeating what you have said, that this is an exercise in futility.
It is. But you see, there's also a certain bad faith underlying some of the actions. And maybe because there are lawyers here, all the four of you are lawyers, so maybe you guys can caution me. But look, when you receive some court, writs, and you read it, and filed by some lawyers, and then you get to know that these same practitioners behind the scenes are trying to plead for their clients. It's repugnant. It makes me explode. And then I decided, look here, show that thing and face the consequences. Bad faith. Okay? You send text messages, a lawyer. You are in court seeking to jail some people for contempt. Behind the scenes, you are pleading for mercy. Hypocrisy. Lack of morality, integrity, moral integrity. It pains me. But you see, I'm constrained. This is rule of law. So you are forced to concede, to agree, and to let the process, however protracted, painfully slow.
You don't seem to entertain any fears for Anas. He is your boy, and there are attempts to get him jailed.
I wish I would take his place. Really, if there was any way possibly to do that, I would take his place. What is prison? For the good cause, for justice, for God and country. But you see, it's a legal process, and I've said so, I have no problem with it. But I want Ghanaians to know that that part of us, that duplicity, that part of us, that hypocrisy, even in the course of this case, is ongoing. And I'm saying so. And sooner than later, I will take a decision that we should expose that person. You don't go out there pleading for 4 of your clients, pleading for mercy. These are his words. And asking virtually for evidence to be manipulated. And then the next time I hear you filed a writ seeking to imprison those who are working for the good of the country. That's why I'm irritated. I'm angry. And I knew today I would not be effective because of the anger, the emotions in me. I have to be honest with you.
They are what you say in law may be germane issues that are raised in the processes, including whether or not Anas actually deserves the immunity that's been granted him and, other things.
I'm not sure Anas has been granted an immunity. I think that we should get it right. If Anas has immunity, it is statutory. And if the law grants it, no human being officer can purport to grant it. If Anas qualifies for an immunity under Section 18 of the Whistleblower Act, it is there. It is a matter of law and fact. And the only exceptions to not getting the immunity are in that section. That it was not true, etc., etc. Okay? Now, what I understand the Attorney General did was to write to Anas to confirm that in her view, he is entitled to the immunity. So it is an opinion of the Attorney General. A it may be upheld by a court or not upheld. But and I've seen a lot of balls bouncing on this issue. Well, who gave the Attorney General the power to grant? Please, we are lawyers. Can you see the letter first before we start saying that the Attorney General has done something wrong? All she did was to express an opinion that I agree with. But a court may agree or disagree. But we live in this country. If there's a change of government tomorrow and another Attorney General comes up and says, where is evidence that my previous Attorney General held this opinion? Where was he going to get it from? So it was smart, it was sensible to ask for that opinion. And I think that we should be able to place that in context. The Attorney General has not granted an immunity. She has confirmed that in her view, he's entitled to immunity under Section 18 of the Whistleblower Act.
That's great clarification.
Well, he's the lawyer. You can take it.
Yeah, the letter. Yeah. Okay. Our attention, this from the Attorney General to Anas, Anas. And actually Tiger Eye. Our attention has been drawn to investigations conducted by you and your organization into some alleged acts of impropriety and corruption involving some members of the Judicial Service of Ghana. We are also informed that you have in your possession some video material on the alleged acts which you seek to make public. We wish to commend you for your continued effort in fighting corruption in our society. As a whistleblower, we further wish to assure you and the agents of your protection against civil and criminal liability under the law. Please be assured that Section 18 of the Whistleblower Act indemnifies you and your agents from any civil and criminal liability in respect of any disclosures made by you concerning your investigations into these acts of impropriety and corruption. Our office is determined to ensure that you and your agents are duly protected under the law. When does this grant? I assure you.
Yes, so it's the law.
It's the law. That I have read the law. I assure you that as far as I'm concerned, that's what the law says.
So like you said, that's confirmation.
So please, lawyers.
The purpose for which the Whistleblower Act was actually passed.
Right.
So it actually within the tenets of that legislation for her to offer such an opinion.
Great.
So I don't think it actually is something that would by all means be admissible in a court of law, or that it's supposed to be. I don't think it actually has any. It's just a very straightforward letter, and it reflects what he's done and the fact that he'll be granted some modicum of immunity. I don't think it's
Before I move on to you guys and get your substantive views on these matters, Kwaku, and as I ask that question, at the back of my mind, I'm reading the headlines that came up, seeking to also bring you into these matters, saying that you are involved in all of these. And I just don't understand how exactly.
I've insisted that the credit, the glory, whatever it is, it's exclusively Anas and his Tiger Eye team. The point about having mentored him and this and all that, I don't think it's of any serious weight. That should be brought into the fore of these issues, okay? But when I'm on a program like this, and the issue comes up, I discuss it. I elaborate. What I know about the young man, I tell.
Right.
And it looks as if that has, attracted some adverse commentary and headlines. And I think it was so unfair. There is this particular headline that I had gone out there to suggest that the Tiger Eye was a profit-making organization, and so many other things. Let me be frank here. This is coming from the Herald of Friday. Before that, it had done a story to the effect that there were gaping holes in Anas's video, and then this one is Anas's secret video sinking deep. The paper is entitled to its judgment of the material that has been put out there, so I don't have a problem. But in so doing, in making the critique, certain distortions are put out there. First of all, Tiger Eye, as I indicated, is a registered private detective agency under the laws of the land. And you go to their website, you will find their position very clear there. It's up there. There's no ambiguity about what they do. This is public. They have clients.
Right.
Okay, the point I was making, which has been misconstrued, and this is their website. The mission says, our ultimate mission is to uncover the truth, wherever it may be. Guided by our core values of integrity and discretion, we aim to create an environment where we can best serve our clients. We consistently strive to provide all our clients with accurate, efficient, and cost-effective private investigations in a timely manner. The next line is our clients. These are some select few. The government of Ghana, MTN Ghana, Interpol, AngloGold Ashanti, Newmont Ghana, Group 4 Securicure Limited, Panos West Africa, Legal Resource Center Ghana, Global Risk Analysis Control RICS. Then they have service rates, different titles, subtitles, undercover agency, they tell you how much. Excuse duty fraud, they tell you how much. Comprehensive undercover investigations, it's there. Deep company due diligence is there. Undercover surveillance on daily basis is there. Secret camera, hidden camera planting, cost is dependent on angles and number of cameras, is there. Deep employee background check. So this is not, it wasn't news that I was putting out, but people were questioning that who funds him, who sponsors him, how does it come by the targets. I thought some of these things they were not looking at the findings of this exercise. Right. So I went into to tell people that this is the kind of organization we are dealing with. There are also projects they undertake on their own. So if people are doubting, I said this company works. If you have a problem with whether maybe they are paying their tax or not, go to the appropriate quarters. If you think they have been corrupted, go to the appropriate quarters. That's all I said. And I said I didn't mind the investigator being investigated. Then comes all these things. And then here, the paper makes a point, and I want to read. The year to visit Hajj, Mr. Bakum, also reiterated his claim that a secret video on the Tama port some 3 years ago, leading to the dismissal of 12 port workers, was financially sponsored by the late Professor John Evans Atta-Mills. This is in sharp contrast to reports that the ex-Minister of Finance, Dr. Kwabena Dufo, contracted Anas to carry on the secret video recording amidst protests from other government appointees. President Mills commissioned it. Even the documentary, you see, it's there. It's public. Yeah. Finance Ministry did the funding in terms of the resources to be mobilized. This is already a public record.
It is.
What is the difference between the president and the finance minister? The president is not the one who pays the cash. Am I right? So who is actually fabricating a contradiction that does not exist here? But the worst part was this, and I want to read this. It says, on the issue of immunity granted Anas against both criminal and civil prosecution, Mr. Bako questioned why the framers of the 1992 Constitution could grant immunity to officials of the military junta who were accused of human rights abuses, including the murder of the 3 High Court justices and a military man. I never said anything to that effect.
Okay.
No, let me just finish. But I made a certain point that, you see, the allegations of corruption against the judiciary didn't begin today, and that it had been here for a long time, and actually produced a Amatekwe's statement dated 24 January 1983, that the reason, the motive, what motivated them to go for the 3 High Court judges was because of the allegations that they had collected monies, bribes, in order to free AFIC convicts. And I was making the point that the distinction between what Anas is doing and what all others had done was that here it is backed with something of evidential value, not anger, not emotions, not mere allegations. And so I was drawing the line that if people are suggesting that those who made allegations, like Chris Akomi, on this very chair, when he was challenged, his evidence led us to the cemetery. So those who want to use Anas's work to vindicate those kind of allegations might as well use it to vindicate Amatekwe. Because Amatekwe could be looking back and say, I said there was corruption in the judiciary. Now Anas has proved it. But that would be an absurdity. It would be a fallacy. So that was the point I made. And then I concluded by saying that what is this big deal about immunity for an investigative journalist under the Whistleblowers Act if we are prepared to grant indemnities to coup makers?
The attempt is,
that's all I said.
The attempt, it seemed to me, to suggest that if what he was doing was for financial gain, then he could not be captured under the Whistleblowers Act.
Fantastic. But that's the law. That's what the law. Okay, in this case, it is not as if somebody commissioned him for a fee to do this particular work.
Right.
And that's why I said there are other projects that they independently crafted. That was that anybody paid.
There are people who are genuinely afraid for Anas, and he should be made to suffer anything like going to jail. Do you? Yes?
I'm not. You must need Anas to know the kind of person we are dealing with. Jail, Anas, he doesn't care. He's been to jail many times to uncover stories. In fact, there's a part of me that thinks that Anas would be very happy if he's jailed in this matter, because it will just boost his profile. I'll be honest with you. He will be very happy to go to jail. But of course, as people speak with him, you know. But so for him, it is not a worry at all. But why would a person like that go to jail? It is true that the offense of corruption is committed both by the giver and the receiver. But in an instant, it is to deal with situations like this that the Attorney General has the discretion to decide whom to prosecute and whom not to prosecute, to decide whom to make a prosecution witness and whom to make an accused. Yeah. And all she has to do is to explain herself under Article 296. That's what the power of nolli prosequi, that I will not prosecute this person, I will prosecute that. And that's a power that every Attorney General has had in the history of this country. And this Attorney General is entitled to exercise that discretion as well, if she decides in the circumstances that she will not prosecute him.
Yeah, and just a moment, this is a rude intervention. In this case, the giver, what was his mindset?
Oh, I was getting there.
Fantastic.
Now okay, we can get into the nitty-gritties of the offense and the state of mind, etc., the guilty state of mind that is required. But before I even deal with that, then we as Ghana, people of Ghana, we pass the Whistleblower Act, that a person who does this is entitled to some immunity. In fact, what is worse, we are supposed to set up a fund to pay him.
That's right.
That is our law. So where from this issue as to Anas, the danger of him being in jail for doing this work? And so both on the law and on what we have all agreed to, this is something I don't see any, my view, there's no chance that he'll go to jail for this expose. Who knows what may happen tomorrow? But there's no chance.
The first point, according to the statute you refer to, is that he's firstly not liable to prosecution, either criminally or civilly. But it does appear that he may have forgotten something, that he was editor or deputy editor of the Crusading Guide. And that is where you find that the lawyers for Justice Derry have gone in.
I'll be extremely careful in speaking to it. But what does his being editor or deputy editor of the Daily Guide have to do with anything? Please. The investigation he did, the investigation was conducted by one legal entity. Yes, he might straddle the two. He might be a director here and an editor there. That other paper is serializing information where it is concerned, where the matter is concerned. But where else would this information be found? Written in the sky? It's got to be on paper for somebody to read.
So it does appear to me that the immunity he gets is not extended to his deputy editorship of that paper, and that's how come he's caught over there.
Well, let's see what the courts will say. You see the same person? Yes. Now, if the information, but let's look at Section 18. In 18 breach by the realization of it, we skills very, and I'm at the point of a very serious issue. Let's not keep. I've been trying to find any similar thing in the history of the judiciary anywhere in the world. I haven't come across one yet. So this is very serious. Now, we must understand that we're going to be bound and governed by a system of laws. That system says that every person is guaranteed a fair trial within a reasonable time. It's a fundamental right that you have. And that right is not diminished because the person allegedly caught is a judge. Now, fair trial means that the person ought to be afforded every opportunity to defend himself or herself. And so we must go through the process. Ladies and gentlemen, it is when we have tested this process that we can see that the process is good or is not good and need to be changed. But this is an opportunity to test our processes. And I think that there are too few lawsuits. I expect a lot more because they must be given the chance to protect themselves. And then another judge will sit down and go through it and decide that this washes, this does not wash, this washes, this does not wash. Samson, when we sit in our offices and we advise so-called foreign investors, that people say foreign investors will lose faith in the economy if this is broadcast. Look, on almost every entry level, you are required to advise on the legal system of Ghana, and to ask questions. What about the judiciary? Is it independent? Is it politically independent? Is it financially independent? Is there bribery and corruption in the judiciary? And our standard answer has been, there is no evidence of bribery or corruption. And when the evidence has been received, the system has tested it. So this coming up blows it up some more. And so we need to test the system for it to stand this test. People, this is a challenge. It is also an opportunity. And we must allow the process to work. Look, that is why when a judge hung a goat thief and a goat in front of somebody as punishment, the judge got suspended. That is not how it is done. But let me tell people something. And this life is full of such interesting pictures from left field. Look, a judge who is accused here last year jailed another judge for 9 months for corruption. The system works, Samson. The system works if we will allow it to work. Indeed, one of the judges that I understand Anas is testifying before on one of his exposés has also been caught by this.
Yeah.
And so the system works. Let's allow it. Yeah, I know there's excitement and everything, but let the excitement die down and let the system work. If any of them is innocent, the person needs to walk. But if any of them is guilty, then the law ought to take its full course. People, let's relax.
Yeah.
I return to you.
Smuggling. 3
yes.
were acquitted and discharged.
Okay.
Whilst 8 were convicted and sentenced.
I return to you to find out how reassuring are the statements that you got, particularly from the Chief Justice, about the process going forward. But Joyce, are you worried about the suits and what the results the suits have brought? The Judicial Secretary issued a statement yesterday, obviously on behalf of the Chief Justice, and it reads that the Honorable Lady Chief Justice is in the process of establishing whether there is prima facie case against the High Court judges alleged to have misconducted themselves in the bribery scandal revealed by Tiger IPI. Out of the 12 who are in active service, 8 have up to Tuesday, September 22nd, 2015, to furnish the Chief Justice with their responses. A Justice of the Court of Appeal, sitting as an additional High Court judge, has been assigned to handle all the cases filed so far in respect of the scandal. Again, sitting on Tuesday, September. Appellate panel has also been constituted to hear all applications that may arise from the decisions of the High Court in respect of the court staff who are alleged to have been involved in the acts of bribery and corruption. Management has, with the aid of the available audiovisuals and still pictures provided by Tiger Eye, been able to identify 80 of them. As the disciplinary authority for junior staff, the Judicial Secretary has constituted 2 committees to investigate the various acts of misconduct. It continues that one of the committees will be sitting next Wednesday, September 23. 15 people in the lists submitted to the Judicial Service by Tiger IPI are not staff of the Judicial Service. The Tiger IPI report indicates that they are staff of the following institutions: Police Service, Prison Service, and the Attorney General's Department. Their names and photographs are being forwarded to the relevant institutions for necessary action. Also, 2 individuals have been identified as private bail contractors. Meanwhile, the 5-member disciplinary committee of the Judicial Council investigating the circuit court judges and magistrates mentioned in the scandal has suspended its sitting in respect of the 14 who have filed a motion in court until the final determination of the suit. The worry of many is that these suits have succeeded in stalling the process. They were hoping, like the Chief Justice said, that there was going to be a swift and decisive process.
Well, I believe there actually has been set in motion a swift response to these allegations. I would like first and foremost to mention that we're all forgetting something very, very critical, which is the public interest as far as this matter is concerned. And I tend to agree with Ace that, yes, largely we haven't heard of any such stories of corruption in any other jurisdictions. But then again, I have also realized that I follow some of these stories every now and then. And whenever issues such as this come up, be it in the newspaper, be it in the public domain, and what have you, with regards to activities of persons within a certain group, specifically individuals such as judges, even the mere whiff of the story, the mere allegation of it, even the fact that it has come up and is within the public domain would normally trigger a certain reaction. And the reaction is that you find more of these individuals who are mentioned, who are part of it, who are seen in these videos, actually taking the first step and resigning from their respective jobs. So for me, that is one thing that so far I have not seen or heard that any of these individuals mentioned in this particular expose by Tiger Eye have taken this action. So that is first. Secondly, whether or not the response of the Chief Justice can be considered as swift or not, I think yes. What else could the Chief Justice have done under the circumstances? The Judiciary Service is guided by rules, by regulations. There is a General Legal Counsel law. There is the Code of Conduct for judges and magistrates. And I believe that there are rules for undertaking disciplinary measures, for investigations into such allegations, and what have you. I believe the first step the Chief Justice actually took at the time was to set up a committee to investigate. I'm sure it was first and foremost to go through the videos. Secondly, to invite persons who have been identified as being recipients of these whatevers to actually respond first and foremost. And yes, I would expect that as we go along, we're going to have several more suits coming up. There have been questions about whether or not a whistleblower should be commissioned, especially in the case of Tiger Eye, whether someone should have instructed them to undertake this particular endeavor, first and foremost. Secondly, whether or not, you know, the other people in the video were actually coerced, they were given certain things under duress, they were caught unawares, and what have you.
From your reading of the law, does a whistleblower, should a whistleblower be commissioned? That's what but you see, I'm just telling you that in the public domain, I would want to err on the side of the general public. I believe the matter is in court. A lot has been said about the legalities already. In my esteemed view, the main reason why we actually insisted on passing the Whistleblower Act was for situations such as this when they arise. That is a question of law. You cannot discuss it in any other way except to respect the law. And these are the tenets of the law. This is what the law dictates. And all the other things that should accompany that legislation have indeed been done. Great. But let's come to the perspective. You to mean, yes. For the avoidance of doubt, I understand you to say that you don't need to have been commissioned. Absolutely not. But that's what I'm saying. I'm just telling you what the perspectives in the public domain are. People are asking all these questions. And I think when we come here, our main duty really is to explain. I would personally have actually wanted to see some people resign as soon as this news actually became public. One tried. At least one tried, which is good. I would have hoped that more would have. That even by mere fact that you are actually in the video, seen and identified, that it should be enough to at least have brought your integrity into question. Enough for you to believe that you can no longer serve in that capacity. Yes, you could actually resign and then, of course, seek legal redress. I don't think anything precludes you from doing that. But secondly, I think that the Judicial Council has its own internal ways of dealing with misconduct by officers of the law. It is the same for lawyers. It is even higher for judges. And of course, there's also the public interest in this matter. And I think so far, for considering what I have seen, yes, the wheels of justice would normally grind rather slowly, but eventually, I believe that we would actually find our feet as far as this case is concerned. Secondly, because the matter is in court, you know, it puts a certain responsibility on us to be careful in terms of the comments that we pass. Because remember, nobody wants to be held in contempt of court. And of course, none of us is actually privy fully to the contents of this particular allegation or videos. And the fact that not all of them are in court. And the fact is that not all of them, but of course some are. And of course there will be others too that are probably still seeking advice and would eventually come to court. But then again,
we must actually see the system working. The cases must be handled expeditiously. Time actually is of the essence in this matter. Listen, there are many great judges out there, persons with very high integrity, individuals who would never be found wanting or culpable in such circumstances. But the few nuts who spoil it actually worsen it for us all. We are all here in Ghana. We know the sort of cases that have come up in recent times. Some have actually called into question the judgments that we have seen in recent times. If there is any reason for anybody to doubt the integrity of our judgments, we must work on it. Judgment deaths have become a challenge and a bane, and the reason is simple, because people will no longer want to select this country as a place or a jurisdiction for arbitration or mediation or cases when they have contractual agreements with individuals. So we must all, as people, not just because we're lawyers, but as citizens, we must ensure that justice is actually seen to be done, that whoever actually works as a judge is a person of very high moral repute and integrity. And I think it is this particular issue that has most been called into question. I actually do not envy the Chief Justice at this time in the history of our country at all. She has a Herculean and a daunting task. All eyes are on what happens in this matter.
Very interesting.
It is not about Tiger Eye, excuse me.
Right.
It could be any other person. There have been several times when even lawyers have complained about the conduct of some individuals. So I think for the first time, we actually have a certain record. What sort of evidential value you can place on it and what have you, for me personally, is neither here nor there.
In fact, Justice Brome will join us and tell us about how exactly they went about the investigations in the 2011 reports of corruption allegations against the judiciary. He was on that panel and has graciously agreed to speak to us about that. Now, Egbert, see, Kofi Asenso says that, God bless the minister, these people should even have resigned by now to give some confidence to the process. This is the thinking of the majority of the people out there.
I respectfully beg to differ. My learned friend to my right, the Honorable Deputy Minister, she's a member of the executive. There have been tales and stories of corruption in the executive. I'm not saying that because nobody has resigned from the executive, we should use that as a baseline and say that nobody should resign from the judiciary. But corruption is a societal thing. From the executive, the legislature, the judiciary, every facet or aspect of Ghanaian society.
This is no ordinary allegation of corruption.
No, Samson, there is a recording. You understand? There is a recording. The recording is yet to go through due process. Where I studied my law, which is the Ghana School of Law, we were taught that a fundamental procedure in the adjudication of matters and injustice is the odi autorem partem rule of natural justice. You must hear a man before you condemn him. Why is the Chief Justice taking everybody through due process with respect to the High Court judges to be able to establish whether or not a prima facie case has been made or established against them? You see, we've been in this country and there was a Tagore tape. We were all caught in a frenzy. They went before the Georgina Wood committee. It ended up full-blown trial at the High Court. People were convicted and sentenced. They appealed. Now, when they appealed, 3 justices of the Court of Appeal came to certain conclusions that tape, ownerless as it was, ownerless, it was an ownerless tape. Nobody up to today has been able to say, I did that recording, at least publicly. And so, in the end, people were acquitted and the appeal was successful. So, yes, there's a tape, and I have watched the tape.
What have the people from whom justice emanates and is administered on their behalf, what have they said about those circumstances? They have said that people hide under technicalities of the law to get away with murder.
But
now we are told that obviously we are not in ordinary times. So the comparison may not be, useful.
Something. You see, then what is everybody talking about? So tapes have come, so everybody is guilty.
But I'm sure.
No, we are not a nation of if you like, beer bar lawyers. We're a nation of trained lawyers. I mean, so to speak.
Some of these trained lawyers have led their clients to the process and have told all of Ghana that when they went there in that committee, their clients saw the video. They began to kneel down and beg for mercy, admit their guilt. So the people have heard this.
Yeah, but so they've admitted, they knelt down and begged. So why is the Chief Justice still proceeding with the inquiry? Because he realizes that if that inquiry is not done, every finding may or can or will be set aside when the people go to court. So we should be bold and tell our people who are using beer bar analysis, beer bar law, to find these judges and others guilty even before due process has been gone through, that you are wrong. You understand? Let me tell you something.
But I'm not sure anybody has done that yet.
So. And
I haven't said you have done that. No.
And I don't think that anybody has actually said
I'll be
that.
very quiet when everyone else was speaking.
Okay.
If I'm making my point, let me make my point.
It's okay, let's hear you.
All I'm saying is this, Samson. For those who know their Bible, one of the first and fundamental basis of the natural law principle of auditor partem, or you must hear a man before you condemn him. When God put Adam and Eve in the Garden of Eden, God is omniscient, omnipresent, knows everything. They were asked not to eat of the forbidden fruit. They nevertheless went ahead and did it under the serpentine theory. God saw them, knew that they had done that. God knows the end from the beginning. Yet God came and asked Adam, that why did you eat of the forbidden fruit? And Adam said, it is Eve who led me into this blah, 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 blah. Why didn't God punish them straight? Why did God ask them? For me, I have come to appreciate and understand that the biblical foundation of that auditor pattern rule is what took place in the Garden of Eden. Sometimes things happen. You know that the person is guilty out and out. But because of this same law and due process, you must put the person through a certain process. And yet there are sections of Ghanaians who say, no, these judges are corrupt, they are guilty, jail them, do this. I am respectfully saying that the tape, as far as it exists today, yes, I have seen it. What I saw, I mean, look, it is, to put it mildly, it is disturbing. But
you've watched the 500 hours.
No.
Is that what you are?
Do with his clients.
My clients.
Okay,
but they relate to several others because.
Okay.
And you see something, but I will not say that because of this thing, all the people there are guilty. No, there are factors which they can use to extricate themselves. Right. Yeah. So let's be bold. Let's be bold and tell Ghanaians that we are lawyers. This concerns law. If you like, procurement of justice, as some person say. But the biggest mistake we do to one another is to just sit up and say, yes, they are guilty. So that is that. Because also, long before these matters came, Kweku Baku will tell you, there have been judges in this country who were dismissed for corruption. They went to court and won their cases and were restored or reinstated. So let us take our time. Let the people go through due process. You understand? And you see, you mentioned, for example, Brobe JSC. Everyone who is a lawyer in Ghana knows the value of Justice Brobe.
Right.
I have brought into the studio Justice Brobe's book, Essentials of Ghana Law of Evidence. He makes a very interesting point. And there's a portion or chapter in his book about illegally obtained evidence. And then, in doing so, illegally gotten or improperly obtained evidence. This is at page 218. Now, he cites Article 18.2 of the 1992 Constitution and says that, look, I'll quote it, that no person shall be subjected to interference with the privacy of his home, property, correspondence, or communication, except in accordance with law and as may be necessary in a free and democratic society for public safety or the economic well-being of the country, for the protection of health or morals, for the prevention of disorder or crime, or for the protection of the rights or freedoms of others. He says this, and then goes to talk about Harvey Litam. You all know this common law position. If the evidence is even stolen, it will be admissible, and all those things, Harvey Sang and all the rest of them. But Brobe, in concluding this paragraph, and makes reference to, if like section 51 and 51(1) and 2 of NRCD 323, the Evidence Act, and the fact that it is the relevance of the evidence that will result in a conclusion as whether it should be admitted or not. But Brobe in concluding says that, and I quote, that general law position in NRCD 323, sections 51(1) and 2, should be considered as subject to the constitutional provisions which are overriding and prevail over any other law, be it statutory or case law. Where the investigations, confessions, or searches breach constitutional provisions, the constitutional provisions will prevail to render the statement, confession, or declaration inadmissible. This is Brobe GSC speaking from his book. You understand? The question now is that when these judges go to court and say that, was I in my house when the Tiger Eye people came? Yes. Was it an invasion of my privacy in relation to Article 18.2? You may find a judge who will say yes. It is a breach of your constitutional right. That's one to Article 18.2, so I will not admit the record. You understand? Maybe the judge will also say, no, the stakes are too high, I will admit it. It depends on the value I'll put on it.
What is invasion of privacy about me coming to your house and having a discussion with you and you endorsing what I say? And I thank you for it, and you're happy that I thank you for it.
I'm not counsel for any of the persons who are, for the judges whose homes, were visited. You understand? So when it gets to that break, they'll cross it. But all I'm trying to say is that if I cannot read your communication, even the everyday bank fraud or phone frauds and things that people do, the police don't just get up and go to MTN or Vodafone and say, give me suspect A's call records. They will go to the High Court ex parte and say that we are investigating a case against Mr. A for maybe rape, defilement, bribery. And we suspect that he spoke to A. Sankuma. You understand? So, to prepare a case against him, the court, behind A's and the suspect's back, will say, so we need the call records of Mr. Ankuma and the suspect before they go to MTN and procure those things.
Yes, I'm not forgetting about that. The Garden of Eden illustration.
Yes, the Garden of Eden illustration is great. And I'm glad you referred to R.V. Sang.
Yes.
Let's remind ourselves of something R.V. Sang also said, Lord Fraser.
Yes.
And so when Eve, taxed with having eaten the forbidden fruit, replied, the serpent beguiled me, her excuse was at most a plea in litigation and not a complete defense.
Yes, of course.
So God went through the process. He taught us how to go through the process. And I bet it's right. We must let the process work. But also making the process work and inciting Article 18.2. We should understand that Article 18.2 has two qualifications.
Yes.
It's not an absolute right.
Yeah.
Yes.
One is that the interference is in accordance with law. That's one leg. Two, and may be necessary. So one law and what is necessary. And so it will be a very good opportunity to test this, to see whether if I come to you and offer you a bribe and you take it, it's a private event. Is the privacy invaded when the person...
of your public...
Is the privacy invaded when I entered your house? I didn't climb into the house. You admitted me.
That's right.
Was the privacy invaded when we started discussing the bribe? Was the privacy invaded when I paid you the bribe? If I hadn't recorded you and left, would I have invaded your privacy? So is the privacy arising only when I recorded it? These are very interesting issues to resolve by the court. Whether if you drive your car to meet me in a hotel and I give you money, is a car a private space? Was the conversation private? It gives you the money private, or it was the fact that I recorded that suddenly makes it triggers Article 18.2.
Yes,
so we are in for that's what I'm saying. Let's let the system work. Because I've heard the points of privacy, I've heard the points of entrapment. Really, let's go back to Justice Brobe's evidence class, to Maxwell Pogradman's evidence class, Justice Fraser's evidence class. Entrapment is if it is by the state. So unless you are going to say that
you mean Justice Foster?
Justice Foster. Late Foster of Apapem. Yes, are you from Apapem? Yes, late Justice Foster, who taught me evidence. Yes. So but I think about some of the times when Egbert's right, us lawyers ought to be a bit circumspect when we throw these things out, because the people have not learned our rules. Let me make a statement, please. Often law, the result of law may not be the truth. It is what can be proved. So if I slap Samson and Samson takes me to court, but I'm able to pay everybody here to say, no, Samson slapped me, and if Samson's went against 10 of us, the weight of the evidence might shift against him, and he might lose. But the fact is that I might have slapped him. But because the judge...
There is video evidence.
Because the judge is not sitting with us or hasn't seen the video evidence, the judge can only weigh the evidence that is put before him or her. Right. And it might result in technically an injustice. But that is the only way we can vet it, that we must weigh the evidence. Sure. With subject to all of these. But sometimes when privacy is thrown in as if it's a defense to a crime, it's not. Entrapment is thrown in as if it's a defense to a crime. Not in our jurisdiction. You can go to America and make that statement. Yes. But in the British common law system, it is not. And so let's tamp down. Let the system work. In terms of resignation, I wanted to make a quick point on that. I think that there's some settled labor law principle that when disciplinary proceedings have been commenced, it is very difficult to allow you to resign, especially if you serve in a public office. Okay. That is why often when you serve in a public office, the employer can say, I reject the resignation, still go through the process. Is that law? Is that not law? All of these may be tested when this comes out.
You can even resign and still go through the process.
Yeah. And let's also remember that this triggers may trigger civil liability, may trigger criminal liability, may trigger the removal as a judge, may trigger you being struck off the role of lawyers. The consequences of this are deep and huge.
And I put it that you are literally finished if you're found guilty.
Literally.
But even before you're found guilty, even the fact that this damage has been done to your reputation, which is why normally we are very careful when we go through these processes. Remember that even the Constitution provides that when judges are found in these situations of misconduct, they must first and foremost be tried even in camera. Don't forget, there is a good reason why that test is set.
Right.
So it is not for us.
And it's not the High Court judges. As for those below High Court, there's no in camera.
No, at all.
So unless try and get to the High Court.
Yes.
If you are below the High Court, there's nothing in camera. Everything of yours is in the press.
I'm taking a quick break. When we return, we would hear the Chief Justice on something she said about this scandal and ask the question whether or not all the judges who are deemed to have been involved in what the Chief Justice calls prohibited ex parte communications are not already guilty before they decided to do anything at all. And most importantly, isn't this an opportunity, like the Chief Justice suggests, to sanitize the system? And I'm looking at it in this context, where in page 137 of Sabbatically Speaking is a book you may like to read, Sabbatically Speaking by Nana Are Damwa. He says that the path that an arrow follows is such that it can only be shot by pulling it backward. So when life is dragging you back with difficulties, it means that it's going to launch you into something great. Is this the scandal that is going to provide the opportunity to launch our judiciary into the finest it could ever be? We'll be right back. You're welcome back. This is Newsfile. This is brought to you by Bank of Africa, MTN, Sasso Spray, Star Assurance, Lipton Tea, and Yum Vita. A few of your messages here, and this one you don't identify yourself. You say, I'm very sad about this unprecedented scandal. These judges must be prosecuted. That's a very central issue also that's come up about prosecutions. And, okay, talking about Gabi being beaten, we'll get there. This one too says that some of us have been vindicated by Dominic Ayene's point that good legal arguments do not matter any longer. You also did identify yourself. Hansen in Takrady says, please tell the police, okay, we'll deal with the police in due course. Thank you very much. Now, I was asking really that question, and I want us to hear the Chief Justice on what she said the judges were involved in. Prohibited ex parte communications. What does that mean? We'll be right back. Let's listen to the Chief Justice.
We are all fully aware of the allegations of grave acts of misconduct made against 12 justices of the High Court and 22 members of the lower bench, which matters have received global attention. But the silver lining in all of this, however, is that it does present us with an opportunity to clean and sanitize the judiciary in order to strengthen the rule of law democracy in Ghana and rebuild public confidence in the administration of justice, which undeniably is at its peak. The alleged include clearly prohibited ex parte communications with judges, and this is generically used, that is judges, is generically used to include magistrates, with a view to influencing the judicial outcomes of those matters pending before the alleged perpetrators. It is.
And that's the Chief Justice. I'd like to begin with Ace. What does it mean? She says what she's seen in the video involves clearly prohibited ex parte communication. What does that mean by the judges?
What she means is this, and it's a very interesting phrase. Her legislative Chief Justice is becoming very graphic in her language. Now, as a judge, you are not permitted, in fact, it is illegal to communicate with any of the parties alone. You cannot. You are sitting in judgment over two people. You cannot have only one party in your presence arguing alone. That is why if you look at our rules, the circumstances under which a party may go to the judge alone, even in open court, called ex parte, are severely circumscribed. Must be an urgency, and that going on notice would mess it up, literally. So what the Chief Justice is saying is this. Let's even assume no bribes were paid. The fact that you entertained a person who claimed to be working for a party in front of you, who is appearing before you, and to discuss the merits or otherwise of the case, what could be done and what could not be done, is in and of itself wrong and illegal. So that in a lot of these tapes, even if no money's changed hands, what the learned Chief Justice is saying is that laws have been broken, let alone when monies have changed hands. And as you are saying, some knelt down to apologize and plead. So that, so that's the point. Fundamentally, there ought to have been no communication. And I think that going forward, we need to state these things on an even stronger basis, right? And those are some of the recommendations, that these ought to be even clearer legislated, so that there's a absolute bar. Please, you are a judge. You are not a village elder to whom people send pleas for mercy. Do not entertain anybody in your office or home or car or by the side of the street who has a case before you, let alone receiving monies. And I think that is the point that the learned Chief Justice makes in such graphic language: prohibited ex parte communications.
Very interesting there. I'm just going through the code of conduct for judges, and there is a portion that speaks specifically to the issue of ex parte communications, particularly B.
Which rule?
2003.
I'm saying now, which rule of the...
I'm reading from, I think this is...
portion that has all of them, yeah.
This is at page 10 or so, page 10.
Yeah, all of these.
There's a B. It says that a judge may consult with court personnel whose function is to aid the judge in carrying the judge's... there's a portion that I'm looking for. A judge shall take all reasonable steps to avoid receiving from court personnel or other judges factual information concerning a case that is not part of the case record. Consultation is permitted between a judge, clerk, or other appropriate court personnel, and a judge taking over the case, the same case or session in which the case is pending, with regard to information learned from prior proceedings in the case that may assist in maintaining continuity in handling the case. A judge consults with a probation officer about a party in a pending or impending criminal or juvenile case. The consultation shall take place in the presence of the parties who have availed themselves of the opportunity to appear and respond. No judge may consult with another judge about a case pending before one of them when the judge initiating the consultation knows the other judge has a financial, personal, or other interest which would preclude the other judge from hearing the case, and no judge shall engage in such a consultation when the judge knows he or she has an interest. So there are quite a lot, there's quite a lot to say about the code, which provides and appear to clearly prohibit, as the Chief Justice said, even the attempt to have a conversation with a party or someone who is related to a case that is pending before the judge, and that conversation is not had in open court for the record of the court. Egbert, does it sound to you as if it's going to be extremely difficult for these judges, even if you didn't receive the money, to escape?
Samson, from what I saw when I watched the tapes, speaking to the ethics, I will say that in a lot of instances there were various degrees of acts of indiscretion and non-compliance with the code. But that is my view. I am sure that if these judges go before the committee, they will have their respective defenses as to why it happened. But speaking for myself and what I saw, generally speaking, I think that the Code of Ethics, as I hold it, it not only, this is Rule 37B, this is Rule 37B, that you've read. There are several other, provisions of the Code of Ethics which have been afouled. But as I keep saying, I believe in due process. Let the people go through due process. Allow them to defend themselves. Well, for instance...
I'm asking this particularly because one of the judges says that in his response to the Judicial Council has said that he did not even touch the money. Yes, it was put on his table, but he rejected it. And it is the other officer, judicial officer, staff, who took the money.
Yeah, I know about that particular case. And, well, as it is, nevertheless, I think my very candid opinion about these matters is that we cannot say that judges cannot be visited by people. But, for example, if you are visited by a person, the person says, I'm Kofi, so I'm Justice Osei Messi. Oh, my Lord, there's this case that you are handling. Say, my friend, stop there. Thank you. If you don't leave this house, I'm going to get my policeman to arrest you.
Which is what some judges did.
Right.
20 judges.
So straight away, you should not allow the person to go beyond any description beyond mentioning his name and then saying that I've come to see you because of a case. Even if the case is before your other brother or sister, you say, walk out. That's the best I can do for you, or else I'm going to call the police to come and get you. So, Samson, it is really going to be difficult in a lot of instances. There's a particular video I've watched where one of the judges, in his or her commentary, made it very clear that he or she knows that she's accountable to God after her work here on earth as a judge, that she will not accept any bribe. If she goes into the matter and it turns out that the person is guilty, he or she will jail the person. If the person is also, supposed to be free, he or she will free the person. I liked it. Yeah, but the issue is, the issue is that it should not have been entertained at all. Of course, even though what came out, was something that was, very nice, so to speak. Point is that once the person says, because even us as lawyers, let me tell you, it is very rare and it is difficult. Once you are appearing before a judge in a matter, to go to the judge and say, my Lord, office, yes. See, this is my case. No.
Very difficult.
Look, you should be able to win your case on your own strength.
Okay.
Rather than go to worry a judge. We talk to judges every day. You understand? In the courts, alleys, and everything. But we don't generally speak to judges about cases we are doing before them. You understand? And I know a lot of judges who will tell you that, no, this person came to my office to do this, and I worked them out. There are several, stories of judges calling lawyers that they are, nice with, and say, look, this is your friend. What does he think he's doing? And it's all to help. So go and tell him, advise him that he shouldn't do that again. You understand? So there are also, if you like, self-regulatory mechanisms, which, all of us as officers of the law can use. But, Samson, truth be told, me, I want to generally say something. These are individual matters, you understand? These are individual matters. But the institution of the judiciary itself, this should be a wake-up call. When you are recruiting judges, you should go as far as to their secondary schools, primary schools to check. The military does that.
They do that if you want to form a church under the Trustees Incorporation Act.
Yes. Because I'm not saying that those of us who wrote exams at the law school and never got repeated or failed in a single paper are better. But I know people on the bench who had their battle passing to be called to the bar. Some of them are judges. You see, and Samson, some of the things that have happened, especially, I don't want to go, it's such an example. When people labor to go through a professional course, they should not find themselves on the bench.
I don't get the point in that because
in the end, I'll put a Sebi on it.
In the end, one of the factors. I don't think
but the point I wanted to make is that
it is true.
Listen,
but I'll come back to that point
34 judges were caught on tape in acts that may, at the very least, suggest impropriety. 20 rejected it. Now, if we're doing the math of the High Court below, is 362 thereabout, and we say 34 took, 20 did not. The rest are irrebutably presumed to be innocent, unless proven guilty. So yes, roughly 10% may be an interesting sample size, but I'm not sure that it brings down the entire judiciary. Maybe if this is investigated deeper, we might find more. That is why I think the process ought to work and should not be short-circuited.
Okay.
I can bet that a lot of these court clerks are going to sing like birds. You think he's going to sink alone? He'd rather sing than sink.
But don't forget that even some of those hired don't want to go down like that.
That's interesting. So we should be expecting that these clerks would even implicate other judges.
Go through the process, because let me tell you what, if I'm a clerk and I become a money bag for a judge and I've been caught on video and I know I'm going to Instagram, I'll take you along. I'll take you along. As long as I can show that you two are collected for you. So right now, I can imagine that there are a lot of people who have running stomachs. That is why we must go through the process. That's why Ghanaians must take their time and let's interrogate these processes with a needle. Because things will come up. So please, the people, chill.
Now, the institutional reforms. Most important. Because we cannot deal with this particular situation and leave out institutional reforms. Look, Samson, you go to a court, you seek an order for, let's say, something emergency. So you go, the judge listens to you, even sometimes on notice, and grants you the application. Samson, you go back to your office, write a letter for a certified true copy of the order, because you need it. Samson, simple process, where a secretary in the court has to type it, give it to the clerk in the court to take it to the registry for the registrar to imprimatur it or whatever, and then you pay. Samson, we have hundreds of such orders in the court system right now. So you are forced to go and push your thing through by paying money. Those are the foundational things, and all these things that happen, this is the superstructure. But the foundation...
And I'll add to that. When a judge has read a judgment in open court, and I said this at the bar conference, and then you are not given a copy of the judgment immediately. It might take you weeks to get a copy. And what you receive is not what you had. What was already in court. Changes have been made. Mistakes that you had, which were going to act as your grounds of appeal, have been fixed between the reading of the judgment and your receiving of it. And people, let's get wise. Right now with technology, Mr. Judge, Mrs. Judge, many people who sit in there holding their phones, you say they should turn it off. They can record everything you are saying.
Right.
It's just that we may not be able to use it in evidence. By the administrative hearings, we can show that, but my lord, you didn't say this in your judgment, but it has appeared in it. Or you said this and it has disappeared. Short of clerical errors, which may be corrected. I think that one institutional reform should be any judge who delivers a judgment order or ruling should immediately there give a copy to everybody.
The Supreme Court has ruled on that.
Yes, I know, but it's not happening. It should happen, but the Supreme Court doesn't do it all the time. How long did it take us to get the election petition judgments? There's serious institutional reform required, and this is an opportunity to fix it.
And I sincerely think
like the Chief Justice says, and President Kufuor and the others think that this presents this country an opportunity to sanitize the system. And like I was making this reference, it brings the point home to me that the path that an arrow follows is such that it can only be shot by pulling it backward. So we're being pulled backward. So when life is dragging you back with difficulties, it means that it is going to launch you into something great. Joyce, is this what you see? We have had a country where our judges have been exported. The judiciary has been in such high esteem that in their country. How do we build that confidence?
Well, I think that there's always an opportunity, there's time that we can always and reconstruct. In fact, for some time, and of course reform other public institutions. There is indeed a call for deeper institutional reforms in our country. Not to say that our judges have not been proclaimed as some of the best, if not the best, the world over.
Right.
I mean, Ghana has had justices who have served as Chief Justice of the Gambia, as judges in Nigeria, in Kenya, in several countries. Justice Bobe is a beautiful example. Just late Justice Foster, Justice Tete, several of them. Recently, I met a female judge, I think, in one of these countries, I don't remember where, who had actually been a Chief Justice of that country and had actually returned. In fact, presently, she's a Court of Appeal judge. So in terms of our reputation, in terms of our integrity, we cannot doubt that we have some of the finest, if not fine, judges in this country. The numbers are not so large, but yes, 10% is still quite a large number.
Even at the level of the international courts.
Let's look at our reputation internationally.
Yeah.
This has been reported on all the international media networks, on all the social media platforms. Just about every nook and cranny of the world has actually heard of justice for sale in Ghana. I think that is indeed a very, very sad development. Listen, Ghana is a country of very beautiful legislations, right down from the Constitution to all of them. The lawyers are guided by professional ethics. And I saw even at one of the programs we had at the bar conference, lawyers who had been struck off the register of lawyers.
Right, recently.
3 of them recently. The processes work. Maybe genuinely we don't follow as they go along. But now we indeed have a wake-up call. And I think it is time for us to take a second look. Whether or not this will dampen our reputation and integrity to the extent that we might no longer be considered as a fine group of lawyers or judges, that I think will depend on how we handle this matter. Listen, there's a good reason why even when a judge has a case and his spouse, his family, or any person related to him is involved, you are actually given an opportunity to recuse yourself from the matter. There are several checks and balances in this system to avoid situations such as we've seen in recent times. Yes, this actually explains that there's always a time for a rebirth, a renewal, and what have you. This time we have a video, whether it's admissible or not, whether it will serve as a reference point or not, whether we would actually use it or not, I think genuinely is neither here nor there. They must indeed go through due process. The process has been kick-started by the Chief Justice. Several schools of thought have actually come up to explain how this should be handled. Lecturers of the law, I mean, several stakeholders have had very good and salient points. But yes, all these things go back to how judges are appointed in the first place. I believe that, in the past, when we were students, there weren't so many judges. I'm sure Osei can correct me. But then the courts were expanded, new ones were added on, and of course, considering the number of cases that we have, we need actually to recruit even more. So yes, them now. So will be individuals who might not have a sort of moral turpitude that you expect from our judges. But that notwithstanding, there are some examples worth emulating.
Right.
Even on this video, some were actually, you know, offered all of it and more, and they still turned it down.
Right.
Even some gave scriptural reasons why they were not going to accept bribe A or B. But all of that notwithstanding, we must see justice not just being talked about or being spoken about, but manifested in how this matter
manifestly
is
done.
handled.
And unfortunately, like President Kufuor said, you say the system works. President Kufuor says it does look like it's sad, though, that it is not a system that is correcting itself or catching those who are doing the wrong things, and it takes an individual, one man, Anas Armiyao Anas, to expose the rot to this extent. Now, I want us to listen briefly to Professor or Dr. Kweku Ansah-Asare. He has a different view, and he seeks to confirm what others have been seeking to say, that ultimate responsibility ought to apply. How is that in this case when judges take their oath individually and are personally responsible for their own acts and failings? Right. Well, before we get there, I'm just getting information that that sound is not really ready. I'll get it, and then we'll listen to Professor Dr. Kweku Ansah-Asare. He is the former director of the Ghana School of Law. He has another view that some people at the helm of affairs may have to take the responsibility for what has happened. Right. And I've got some messages here, though. This one says, I'm in Takwa and I will travel to Accra on the 22nd to watch the video. Please tell Anas and his team I don't want to be disappointed. The video must